Welcome to Rappahannock Issues. I'm Tom Coen.
And I'm David Kerr.
And we're going to be looking at topics that are of interest to our community, both regionally and to the state. Welcome to Rappahannock Issues. I'm Tom Coen. A major issue facing the U.S. right now is the Supreme Court and the vacancy caused by the death of Justice Scalia. And to help us with this, we have with us Travis Braidwood, who is Assistant Professor of History, Political Science, and Philosophy at Texas A&M University in Kingsville. So welcome, Travis.
Welcome. Thanks for having me.
Our pleasure. First off, the death of Scalia was rather unexpected. And it was a major development. So what do you think his legacy is going to be on the court?
Well, Scalia has a few major things that he brought out and brought to the court. I think probably the most two that he'll be known for is one is the introduction of a judicial philosophy, a judicial jurisprudence that embraces the notion of originalism, where he's looking at the Constitution as he and maybe historians would interpret as their original intent as opposed to reading more into it. And then the second is that Scalia also interestingly brought the importance of oral arguments to the American public. The Supreme Court started originally allowing oral arguments to be recorded in the 60s, but if you listen to some of the oral arguments from the early decades they're really quite boring. There's no questions, there's no excitement, it's very dull, and then Scalia joins the bench and he peppers people with questions, and he's sarcastic, and he has quips, and he has these anecdotes, and no one had seen anything like it. And then since then, justices that have joined the court have adopted that idea of interrupting attorneys, peppering them with questions, forcing them to really explain their reasoning.
And could you just go into a little bit more about originalism versus what had been in the past and what some of the other justices, particularly the more liberal justices, do?
Sure. So the idea of originalism, also known as textualism, had actually been around for a while, and Justice Scalia had previous experience as a federal judge on the Fifth Circuit, but it had never really been practically applied by a justice on the Supreme Court. It had been more a matter of debate and speculation in academic circles. When he joins the court, he embraces this idea as a practical application of a judicial philosophy. And the idea is relatively simple, and that is that the Constitution, as he would say, is dead, and that it cannot take on new meanings. So if we're looking for a way to interpret the Constitution, we simply look at what the founders meant, as best we can determine from historical records, about the intention of the provisions within the Constitution. So, for example, if for Justice Scalia, the question of the death penalty is very simple. Cruel and unusual punishment would be who was executed at the time of the founding. Were children executed at the time of the founding? Yes. Therefore, the answer must be they could still be executed today. This is in contrast with what more liberal justices would embrace, and that is the notion of functionalism, or a living constitution theory. The idea that the Constitution must bend or else it could break. And the idea that as we develop new things that the founders never conceived of, the Constitution therefore must take on new meaning. Ideas like privacy, or as Justice Breyer is often fond of citing, the Internet. George Washington, John Adams, Jefferson, they could have never conceived of the Internet. And therefore we must have a Constitution that can also conceive of something that they did not anticipate.
And with the functionalism, and some of those other justices are more for judicial activism rather than restraint. So can you go into the difference between those concepts?
Yeah, I think that another thing that sort of satisfies this underlying idea of judicial ideology, which we typically don't associate with liberal conservative as much as we do how you interpret the Constitution, is that exact idea. And that is, when you have originalism, it maps on nicely to this notion of being restrained, not reading in new rights, because by definition, if the Constitution is not alive, new rights cannot be read into it. This is opposed to this idea of this functional living constitution idea, where you can say there can be new rights that are derived out of the Constitution because we had never confronted those things before. Interracial marriage, same-sex marriage, these things were never conceived of at the founding. Therefore, there could be a new meaning to provisions that came along later. Right?
And Scalia, I believe I've watched him on different venues say the response to that is we have the amendment process. The founders had put in the process, different ways to amend the Constitution. Therefore, it's not as though they can't be put into the Constitution. There's just a formal process rather than an informal.
I think Scalia, if you had to maybe cite him with one fault, is that he was maybe deceptively humble. So whenever it came to matters of legislative affairs, he would simply say, well, I'm a justice on the court. I'm not capable of rendering these sort of decisions. That's a matter for the American people. That's a matter for Congress. In reality, he's fully capable of realizing these things. But he wants to simply push it off and say, look, you don't like the way that we rule in these cases. You want privacy. You want rights to contraception. You want abortion. Pass an amendment. Pass a piece of legislation. Then you can handle it and let the American people decide, not 9 members in black robes.
And with the 9 members in black robes, there's always majority opinions and then there's some minority opinions. And so what would you think? He's more famous for his minority opinions rather than majority opinions. And can you sort of touch about his role on that?
Yeah, I think that's largely the process of the way the court works, and that is that if you're going to write the majority opinion, you have to rope in the remaining, if it's a split decision, 4 justices. So you have to moderate a bit in terms of your language. But when you're in the dissent, it's a free-for-all. You can say really anything you want. And so his dissents were known for being biting, sarcastic. He also pulled in language that wasn't used in the judiciary. He pulled in non-legal language. He was a big reader, especially in German philosophy, kind of oddly, and he would pull in words that are not in common usage and employ them for the purposes of attacking his opponents.
So how do you think history is going to view him as a justice?
I think he'll go down as one of the big intellectual giants of the court. Despite the fact that he wasn't a chief justice, he was never presiding over a court. He was on the court for quite a long time, and you might think, well, he blends in with the number of other justices. What really makes him stand out? But I think the change that he brought to the court in both its practical behavior and in the language that it uses will resonate and be fixed as a constant, permanent thing within the Supreme Court.
And we have a little bit over 2 minutes left, or about 2 minutes left. So we'll just deal with him again. He was sort of an eclectic or a Renaissance man. I mean, he liked the arts, he liked philosophy. I mean, it wasn't just I'm a professor of law or I'm a judge and that's it.
Yeah. Oh, yeah. Yeah, he famously was friends with Justice Ginsburg. They were both big fans of the opera. He, despite his sometimes acidic tone, he would often form friendships with people across the political spectrum, and I think that also won people over. He was known for being bombastic but congenial.
Right. Okay, we have about a minute left. So with the replacement, and we'll get more into this in another segment, but there is a controversy about trying to replace him as far as intellectually. We'll deal with just the intellectual right now.
Of course, now since we have a Democrat president, we're wondering whether or not the balance, you could say, was perfectly split. We had 4 on one side, 4 on the other. We had a moderate with Justice Kennedy, rather. And now the question is, can we replace somebody that would satisfy Republicans who control the Senate that would fill the ideological vacancy, namely a hard-line conservative?
All right, and we have about 30 seconds left, and it'll be hard to replace going into more of these issues with Travis Braidwood. So come back after this break, and we'll keep going into the more current issues with the Supreme Court and some of the cases this term. So come on back after the break.